Hi, everybody. Thank you for joining us for another edition of Condo Insider. So as some of you may or may not know, so ThinkTech Hawaii had, who we used to use for Condo Insider, they have completely retired, and that was effective end of April. So it caused us to, in order for us to continue, we had to create our own YouTube channel. And so we're kind of like doing on, we found a new media person, Ikaika, with Key Media. He is our head guru when it comes to all of our Condo Insider recordings. And we're really appreciative to have found him actually, and continue on with Condo Insider. So today I have with me John Knorek with the law firm of Torkildson Katz. And he is basically the go-to person that as far as long as I've been a condo owner, that is where managing agents, the property managers go to when they have labor questions. He is a frequent speaker with Hawaii Council on our board of director training that we do every year. Pretty much it's been like every July. And so welcome, John.
Thank you.
Appreciative of you coming back again. And we're going to really talk about the new laws requiring the overtime exemption rule. And this applies to especially resident managers, some of your on-site people. So I will let it go to John.
Thank you. Thank you for having me back, Raylene. I appreciate the opportunity to share some of this information with your condo associations that are members and those that might just be tuning in. There's a significant change in employment law that happened this summer that I think impacts or could impact many associations. And it has to do with whether somebody is deemed exempt from overtime under both state and federal laws. That means that whether or not you have to pay time and a half after 40 and track actual hours worked in order to comply with federal and state law and avoid the penalties associated with that law. Most people think that their resident manager or site manager is exempt because they're salaried. And as I'll explain today, simply being salaried is just not enough to get you out of the overtime obligation. So let me begin with that. So what we plan to do is we're going to just kind of go over what the exemptions are and then tell you about what the final rule change was and let you know there's still some fighting going on over it, but some things that you might need to do. So the first thing is there is a federal law called the Fair Labor Standards Act, and it applies to any enterprise that has at least $250,000 of income or expenditures per year in interstate commerce. And getting into interstate commerce is as simple as buying things at Costco or Walmart. That puts you in interstate commerce. Clearly making phone calls to owners that might be out of state is interstate commerce. Collecting maintenance fees from out-of-state owners is interstate commerce. So most condos, and I couldn't find one that was small enough that it had less than $250,000 budget. There might be, but if you don't have $250,000 budget, that doesn't exempt you completely either. So first of all, if you have $250,000 budget, you're covered by the federal law. If you don't, any individual working for you that is involved in interstate commerce is individually covered by the law. And that means that that person is entitled to the protections of minimum wage and overtime if they're not exempt. So if you're a very, very small condo and you have a resident manager that goes to Costco and buys product, he's engaged in interstate commerce. So he's covered by the law, even though as an enterprise, all of your employees are not covered. So that's the first thing. The second thing is there's a state law. And the way the federal law works is whichever law provides greater benefits, that provision will apply. So you basically have to comply with the exemptions for both state and federal law to avoid overtime liability for any of your employees that you want to treat as exempt. So remember, this law provides that you have to pay minimum wage and overtime after 40 hours worked. And it is your obligation as the employer to actually track the daily and weekly hours worked. Most organizations and employers think, oh, I'll just tell the employees to fill out a sheet and they'll fill out the 8 hours a day and turn it in at the end of the week to the property manager or whoever. That's fine, but it is, just so you understand, it is the employer's obligation to accurately track those hours. So sometimes you want to make sure that employees are accurately recording their time and remind them that they're supposed to record all the time worked and not just write down 8 hours and a half hour for lunch or whatever, that they're actually tracking their real time and that you told them that, so that if there's any dispute over how many hours they were really working, and I've had this happen repeatedly when we mischaracterized a manager as an example. They'll say, oh yeah, I came in every weekend and I had to turn on the water, sprinklers, or clean the pool, and I had to answer phone calls in the middle of the night about 2 or 3 times a week. And so, yeah, I worked 50, 60 hours a week. And then you're talking about 20 hours of overtime under state law, what could be 6 years, and under federal law, which could be 3 years of back pay on overtime. And at time and a half, that can get pretty expensive. So even though you might salary somebody, then you have to figure out what their hourly rate is in order to figure out how many hours of overtime they get. So it's a complicated mess and it can get very expensive. Okay, so to be exempt, how do we make sure somebody's exempt? First of all, you have to be paid on a salary basis. Salary basis means you get your weekly salary. Everything under wage and hour law is on a week-to-week basis, meaning you get your weekly salary regardless of the quality or quantity of work that you perform. That means if I am a manager and I decide to take off in the afternoon to go watch my kids play soccer, you cannot dock my pay. I get my weekly salary regardless. I get sick, I won't leave to go home, you cannot dock my pay. There's some exemptions to that. I can draw down your sick leave bank. I can draw down your vacation bank when you take time off, or PTO bank if that's what you have. But once that's exhausted, you cannot deduct from the salary except whole day absences after they've exhausted sick leave, or whole day absences after they've exhausted all their vacation and or a PTO. Okay, so paid on a salary basis at a salary level of at least $844 per week. That's what we have to make sure. That's the new level under the exemption. So there's a salary level, and that changed as of July 1st. So now to be exempt, you have to make $844 a week. The next thing is you have to meet a duties test, and you have to be performing as your primary duty the duties, and we'll talk about these, as an executive, administrative, or professional employee. Oops. There is another category under federal law that does not apply under state law that says if you pay somebody at least $132,964 a year, and there are a number of resident managers throughout Hawaii that are paid at least that amount or more, and that they would be exempt from overtime if they perform some of the duties of either an executive or administrative employee under the test. So they don't have to meet the more detailed exempt executive, administrative, professional if you pay them at least 132. Okay, so that's federal law. That's where we're at. State law has a much lower weekly salary requirement. That is a salary of $210 a week, and they have to meet the duties test. And I'm going to cover these duties tests later. But most Hawaii employers have been relying upon something that's in the state law that's a catch-all exemption from state law. And up until June 21st of this year, it had been a guaranteed salary of $2,000 a month. Well, that's $24,000 a year, and there's very few resident managers or site managers that were being paid less than $24,000 a year. So everybody was pretty comfortable saying that they're exempt from state law, and I don't have to worry about the state law requirements to track employees' daily hours work. I just have to think about whether they're exempt under federal law. However, they just bumped that up June 21st to $4,000 a year. So $4,000 a year is $48,000, which is a significantly higher number than the 24 it has been. And in fact, $48,000 is higher than the federal salary level to be exempt. So many businesses that are paying their resident manager or site manager less than $48,000 a year right now have to go and look to make sure, are we paying them overtime? And if we're not paying them overtime, do they fit some other exemption under state law? And would they meet the exemption under federal law? So we're going to have to look at the salaries that we're paying. So anybody that's getting paid less than $48,000 a year, you're going to have to look at and understand whether they meet an exemption test or not. And then boost them up to $48,000 a year if you want to be exempt from state and federal law. Okay, so Hawaii and federal law are kind of similar in the executive exemption duties, and that the exemption duties for the state law is an executive is somebody, first of all, who's salaried at a salary level. Federal law is $844 a week, state law is only $210. Okay, but $844 a week, and whose primary duty consists of the management of the enterprise in which the individual is employed, or of a customarily recognized department or subdivision thereof. So your resident manager is going to meet that aspect of the test, and most likely. If you have like a maintenance manager or a grounds manager, they may even meet the test. But they also have to customarily and regularly direct the work of 2 or more employees. There are many condominiums where your resident manager or site manager is your only employee, and their primary duty is probably keeping the place clean and maintained, as opposed to managing the enterprise. Now, there are some organizations where your resident manager or site manager, of course, is in charge of coming up with a budget and taking care of maintenance and managing all those projects and all that. But if they don't supervise 2 or more full-time employees, they're not going to be an exempt executive under state or federal law. In addition, they have to have authority to hire and fire those people, or effectively recommend their hiring and firing to somebody. And in addition to that, they have to regularly and customarily exercise discretionary judgment and powers. So the kicker in most situations is, do I have 2 employees, full-time employees I'm supervising? And the problem you sometimes have is if you have a resident manager and an assistant manager and only 2 employees, only one of those people can be exempt. You can't have 2 people supervising the same 2 employees. There has to be 2 full-time employees for each person that you're going to consider to be exempt. You can't count them twice. Okay, so that's the first thing. So $48,000 a year, supervise 2 or more employees, authority to hire and fire them. Okay, if you meet that, you're probably exempt. State law has a unique exemption called a supervisory employee. This does not apply under federal law. Executive applies under federal law, as we just described, but state law has a separate one. If you supervise 5 employees, you're exempt under state law and paid $210 a week. $210 a week. So if you're not the main guy in charge, but you supervise, or even if you are, but you can't hire and fire, if you supervise 5 or more employees, you're exempt from state law, but not federal law. You could be if you also have authority to hire and fire those 5 employees, but you don't have to have authority to hire and fire to be exempt under state law if the number of employees you supervise is 5 or more. So that's good. There's also something called an administrative exemption under both federal and state law. And generally, these are positions that are like assistant manager, somebody that's engaged in back of the house, accounting functions, human resource functions, those kind of things. It's applied somewhat narrowly by the U.S. Department of Labor, but the courts are starting to open the doors for businesses to meet these exemptions. So an administrative exemption applies to a person whose primary duty is the performance of office or non-manual work directly related to management policies, general business operations of the employer or customers, and the work requires the exercise of independent judgment and discretion. So what they give an example under state law is somebody who directly assists a proprietor or individual employed in a bona fide executive or administrative capacity. So an assistant to somebody who's exempt might be an administrative employee, and who performs only under general supervision along work lines requiring technical knowledge, special training or experience, and who executes only under general supervision. So there's got to be some freedom and independent judgment and discretion to make somebody an exempt administrative employee. Secretary that just types up things and handles paperwork that doesn't exercise independent judgment and discretion over in federal law matters of significance to the employer is not going to be an exempt administrative employee. I don't like trying to fit people into this category because it's very difficult to meet. So you might be able to find some resident manager, site manager who keeps his hands clean, is not a working manager, just handles the budget, just handles personnel issues, might make this exemption, but it's a tough one to meet under state and federal law.
Well, independent judgment, how is that going to be like if they're have the power to enforce house rules? That wouldn't
again, it gets complicated because if you're enforcing house rules and it's a set guideline, that's not independent judgment and discretion.
Okay.
So an example, and under federal law, it has to be over matters of significance to the employer. So the question is, what's a matter of significance? Are house rules or is it money? So if a resident manager has authority to contract with a contractor and commit the association to a $500,000 project, that would be independent judgment and discretion over matters of significance. The cases that have litigated this have to do with insurance adjusters. There were a lot of cases of whether an insurance adjuster is an exempt administrative employee. And basically they said the guys that look at your car type into their laptop whether the damage to the car is to your Camry 2020 Camry right front fender, that's $2,000. That's not independent judgment and discretion. It's just wrote out on a program for you to figure out. Yeah. Whereas the insurance adjuster that looks at your house that got burned down and negotiates with the lawyers as to how much to pay to rebuild your house, that person is probably exempt. So there's a gap there between those two somewhere, but it's not a black and white line. It's a pretty gray area. So that's one of the reasons I try to avoid administrative exemptions unless it's clear that person has independent judgment and discretion over some significant matters for the association. There's two other categories that are exempt. I'm just going to mention professional, and there's one called outside sales. And outside sales wouldn't apply to condominium associations. Professionals probably will never apply to anybody. There's two kinds of professionals: the learned professions, doctors, lawyers, sometimes CPAs, teachers, somebody with an advanced academic degree, and they exercise discretion and judgment in performing their work, and it's a mental exercise. That's kind of a learned profession exemption. Again, they have to be salaried at the level that we're talking about. And then there's the creative professionals, musicians, artists, and those kind of people that exercise creative judgment over matters. That's not going to apply to you in most cases. So we're stuck with the executive and maybe the administrative exemptions. So these new rules, as I mentioned, are focusing on the salary level. There's no change in these duties tests. So what I've been describing as the executive functions and administrative functions, that's been a law all along. It's just, and the salary basis test has been the test all along. It's just the salary level that's changed. And so under federal law, the Department of Labor estimates that 4 million new workers will be entitled to overtime unless they get a raise. And if you want to avoid being liable for misclassifying somebody and not paying them overtime they're entitled to, which the U.S. Department of Labor now calls wage theft, you want to make sure that you've not misclassified any of your workers. And that basically means looking at who you're treating as exempt salaried now, making sure that they're at the new salary level to be exempt under state and federal law, shorthand 48,000, and that they are truly exercising the authority that would make them an exempt executive and or an exempt administrative employee. So here's the chart that says here's where we're going. This is how it's moved. Just to give you a little bit of background on all this, in 2004, the weekly salary level was $455. In 2016, under Obama, he tried to double it, but it got into the courts, and the courts enjoined the Department of Labor raising it to $913. And then in 2019, they put forth regulations that raised it to $684. And that worked. And then in just this year, 2024, it's been raised to $844 or $43,888 as of July 1. Now that goes up again in January of 2025 from $844 a week to $1,128. So if you're looking at budgets for next year and you want somebody to be exempt, forget the 48. You got to look at 58, 656 for January 1, 2025 on. And then every 3 years, starting July 1, 2027, it's going to be adjusted based on inflation, cost of living analysis. Okay,
so besides the budget, they're going to have to, they may have to realign their responsibilities, or they're authorized, like if they're authorized to expenditures, like they may have to think those, that they have the authority for up to X amount of dollars for expenditures. Because I know we're working on our October one, and that was one of the things recommended tips, but we may have to rethink that slide.
Yeah, you want to make sure they're exercising discretion and independent judgment as an executive over matters. Now, if it doesn't necessarily have to be over money, as long as they're supervising 2 or more employees and have authority to hire and fire them. And the majority of the time, they're not doing manual work. They have to be non-manual work, majority of the time. So that gets dicey when we have working resident managers. Okay, so that's the numbers that we're going to be looking at now: 43,888 or 844 a week, and January 1, 58,656 or 1128 a week. Now, the highly compensated executive test I told you, that where that went up to 132,964 on July 1, it's going up to 151,160 or January 125. So in order for you to be an exempt, highly compensated employee, where you don't have to have all of the functions that are defined, supervise 2 or more employees, authority to hire and fire, just that you're generally in charge and running things. And if you're paid at 151, you can be exempt as well. This becomes an issue for a lot of associations. Well, we're providing housing, and the housing is worth $2,500, $3,500 a month, so we easily meet that test. No, you cannot consider the value of housing or benefits in calculating that salary, that weekly or annual salary. So the laws say it's a fixed salary exclusive of reasonable cost to the employer, board, lodging, or other facilities. That's the state law. Federal law is the same way. You can't consider any other things. It's negotiable money, check or cash, that you have to pay as a salary. Now, there is one catch under federal law. It doesn't exist under state law, that up to 10% of the salary of a highly compensated employee or executive can be in a year-end bonus. So if you salary them at a lower amount than would meet the 58,000 in January of 2025, as long as you make sure that you give them another $5,800 at the end of the year to make up that 10% differential, you're okay. Now, that just becomes very complicated for businesses to make, if they at the end of the year decide they don't want to give somebody the 10%, then they're not exempt, and they have to go back and figure out how many hours of overtime they work and pay them overtime. So it doesn't really work well for
Yeah.
avoiding the potential liability for most businesses, unless you just want to defer the expense to the end of the year. Now, all this took effect July 1, but there are 5 cases out there pending right now that may impact this law. There are challenges to the law. Obviously, the place everybody gets sued. When the government gets sued, they get sued in Texas because the Texas judges don't like the federal government telling them what to do. And so whenever you want to sue somebody, sue the government, you go to Texas and sue them. So there's 3 pending cases in Texas. No decisions yet, no indications that it'll happen. But any decision from a district court judge in Texas gets appealed to the Fifth Circuit Court of Appeals. There's one pending now, but we don't know what's going to happen. And sometimes these decisions are limited to the states in that jurisdiction. So they may issue an injunction saying, oh, this Department of Labor can't enforce this regulation. It's beyond their constitutional authority. And they may say, okay, for the states of Texas, Oklahoma, and whatever's in the Fifth Circuit, Louisiana, Arkansas, this law doesn't apply. But the Ninth Circuit Court of Appeals, which is the jurisdiction that covers Hawaii, they're far more liberal in allowing the federal government to regulate things. So, something could happen where this law gets held up again, but it's going to take some time to get it enjoined. And we have to tell you, it's the law now. The Department of Labor is enforcing it in Hawaii and against the businesses in Hawaii. So you're going to have to comply with it until and unless some court somewhere says, no, you can't. This Loper case is interesting. This is a Supreme Court case that was handed down in June. It does not apply to the Department of Labor's wage and hour regulations. But what it said is significant across the board. And I'm just going to mention this because this was what throws everything up in the air. Traditionally, the Supreme Court and federal courts have given deference to interpretation of the laws by the agencies that are in charge of enforcing them. It was called Chevron deference after a Supreme Court case years ago. That's been the way the courts have dealt with the federal agencies changing the rules on how the laws apply for decades. Supreme Court this summer said, well, we're not going to do it that way anymore. We're not going to give agencies discretion. Congress has got to decide. We're going to look at the plain language of the statute, and that's how it's going to be applied. Well, there's nothing in the statute that says what the salary should be or is. So the agency is setting the salary level based on what they feel is the appropriate level given the circumstances of the country. And so we're going to find out maybe someday, maybe this year, maybe a year from now, maybe 2 years from now, that the Supreme Court says, nah, Department of Labor can't change the salary level. Who knows? But until then, you are exposed to liability from the Department of Labor. And so it's best to figure out how to comply. All right, so take a look at your internal pay policies, communicate the changes to people, review other policies to see how they may be impacted. When you start raising salaries, that puts everybody at a different level, and they're going to say, how come they got a raise and I didn't? And so you're going to have those kind of morale issues. If you're going to not have people exempt, then you're going to have to make sure they're tracking their hours worked on a daily and weekly level. Daily, they have to record the hours worked. Then we'll keep an eye out. You'll hear from me whether there's a challenge to the challenge to these cases. And if you have legal counsel, go ahead and give them a call and say, what do I do? We haven't been paying our resident manager $48,000 a year since July 1. How do we fix that? And we can walk you through the adjustments. So there's, once somebody falls out of an exempt status, they're entitled to overtime, and you have to start tracking their hours. So you can do that. You don't have to treat people as salaried exempt. And I do this pretty often. We write resident manager agreements that say you're hourly. You get $30 an hour. You're going to get $45 for overtime, but we only want you to work 30 hours in the office a week and save 10 hours for weekend and after hours work. But write it all down, and if you exceed 40, we'll pay you time and a half. And there's some ways of avoiding that, but it's more complicated and unnecessary to kind of cover right now.
So, like keeping track of their hours. So I know some people, some resident managers, they keep a log. And
Mhm.
like you said, 30 hours, the other 10 could be for like, some of the off hour, I mean, the out of the business day
Yeah,
kind of time frame. But could that be the tracking of and their log
sure.
it's really like an incident log. It's very like a diary almost for them.
It's yes, that's fine, but again, somebody who's doing payroll has to get a report from the employer, whether it's directly from the resident manager, site manager, or through the property manager. Somebody that processes payroll that looks at the work week and adds up the total hours worked in that work week for each day of that week and determines whether it's over 40. So if
Okay.
you're not exempt, each hour over 40, you're entitled to time and a half. So the way what I'll get into some of the trees here. Let's say we've misclassified somebody and they're salaried and we're paying them $40,000 a year. Or let make it simple. Oh, okay, $40,000 a year. The way you figure out what their overtime rate is by taking that 40,000 per year, dividing it by 52 to get a weekly salary. So whatever 40,000 divided by 52 is a weekly salary. And then you look at how many hours did I work in that work week. So if it's 40 or less, no problem. But if it exceeds 40, let's say I worked 50 hours, then you have to take that weekly salary, divide it by 50 to get an hourly rate. So you've paid the straight time rate for all 50 hours with that salary. So for the 10 hours of overtime, you take 50% of that hourly rate times 10 hours of overtime, and that's what you owe that employee. So the hourly rate and the overtime benefit could change week to week depending upon how many hours overtime a salaried non-exempt employee works. So it gets really messy to have salaried non-exempt employees because their overtime rate can change week to week depending upon how many overtime hours they work. So if you're gonna have a non-exempt resident manager rather than a salary, you're gonna have an hourly rate.
Okay.
And then that hourly rate's set forever and it applies.
Does that the amount of hours they work in a day, can it be like split up? It doesn't have to be consecutive hours. Because
Sure.
sometimes there's resident managers that will, they'll do a lot of things in the morning, but especially if they're doing outside stuff, it gets too hot,
Sure.
so come inside, do maybe admin stuff or take a break and then maybe go back in the late afternoon when it's cooler,
Sure.
which
Yes.
sometimes is cool because then people can see him or asking questions that, I've been meaning to call you and talk to you about this, blah, blah, blah. But at least he's out and about so that,
And attending board meetings or going to committee meetings at night
Right.
and all the rest.
Right.
Sure. It doesn't matter when they work or whether it's split shift, however you want to categorize it.
Yeah.
There's
Okay.
no restriction on that person working different times throughout the day. So but you have to pay them for all the time worked.
Right.
Some of
And
the new, yeah, go ahead.
I want to also, because I get this quite a bit from people, they're not here. Aren't they supposed to be here 24/7? I go, no. Are you paying them for 24 hours worth of work? I go, they're not handcuffed to the property.
Right. And then that's part of the dilemma for a lot of associations, that they believe that they should have that coverage for 24/7. That's why they're providing housing for that person. We get into this sometimes when we write the resident managers agreements, because a lot of associations feel like they're giving the employee a benefit by giving them housing. Unfortunately, the way tax law works and the way employment law works is, if you are giving that as part of their compensation, he has to be taxed on it and you have to pay the employer's portion of the tax. hardly anybody does that, because that's kind of part of the industry that I live on site, and I don't have to pay taxes on the value of that housing. That's a good benefit, but in order to make that work under tax law, the employer has to say it's for their benefit that the employee lives on site, that the employee's residence on site is to fulfill their responsibilities as a resident manager. And that means whatever happens at night, handling emergencies, replacing keys, whatever might be their duties on off hours. So that's partially how you get out of having to pay taxes on the housing, by making it clear in the agreement that the housing is provided as a condition of employment for the benefit of the employer. That also works very well for employers, condominium associations, because if the employment relationship ends at some point and you terminate the employer, they quit, the residency in that unit, if it is a condition of employment, is outside of landlord-tenant law. You don't have to comply with 45-day notice. It's summary possession law. It's 10 days written notice to vacate. You can go to district court and get an eviction order, much quicker than if you had to go through landlord-tenant law. So associations should be careful not to get into situations where they tell the resident manager, "Oh, go ahead and go rent something and we'll reimburse you." That gets complicated, because then they're a tenant and they're entitled to that to the residency under a landlord-tenant law with whoever the owner of that unit is. Your contract with the employee then is involved because you've agreed to pay for that, right? So that becomes a problem. So normally and usually what we try to do is have if it's a common element unit, if it's the resident manager's unit, it's owned by the association. That's the simplest way of handling this. That, you get that unit, and when the relationship ends, you have to leave in 10 days, or whatever you put in the contract. So many associations want to give them 14 days, or some have even gone as far as 30 days, just to be nice. But I tend to say, the minimum is 10 days, and that's usually what I recommend.
Because that kind of shortens the window for any kind of ill-gotten or creating
now
habit.
here's a weird twist to the value of housing, and that's if you are a non-exempt employee, meaning you're not exempt from overtime, then an employer can take a credit for the value of housing towards satisfying the minimum wage obligation. But almost everybody pays at least minimum wage to a resident manager anyways. So even if you're not exempt from overtime, very few people are going to cut their pay so low that they get an offset for the value of housing. And that only applies under federal and state law for minimum wage obligations if it's historically traditional for that kind of a position to be given housing. And it is in your industry. So in an unusual situation, if somebody wants to try to reduce their financial liability by taking an offset for the value of housing and treating their manager as a non-exempt hourly worker, you might be able to reduce your exposure or liability a little bit by taking that credit. But then again, what happens is if it's not provided as a condition of employment for the benefit of the employer, that value of that housing gets taxed to the employee and it's part of their wages. So if you're taking a credit against minimum wage for the value of housing traditionally provided to people in that area, then that employee is going to show on their wages the value of housing for that month, and they're going to have to pay taxes on it as well. So it's not a good thing for either side in the long run. Okay. So that's the dilemma with housing. It doesn't really factor in when you're trying to make somebody exempt, and regularly associations want to take credit for that, or oh, I'm paying for health insurance, or I'm giving them X number of weeks of vacation. None of that matters. It's a weekly cash salary and negotiable money. So non-compliance is a problem because under state and federal law, you might owe back wages to somebody if their salary is too low to make up for minimum wage, which is now $14 an hour and going up in a couple of years. Under wage and hour law, under federal wage and hour law, if I fail to pay you your overtime, and let's say I owe you $100 a week for the last 2 years, so that's $5,200 for year one, $5,200 for year two. Okay, I owe you $10,400 for the overtime I didn't pay you. But in addition to that, you have to pay liquidated damages to the employee in an equal amount. So whatever you owe, you double.
Wow.
And under federal law. And under the current administration, that's automatic. Now, if you have relied on legal advice, if you've got a written legal opinion from a lawyer that says, no, this person should be exempt, and you relied on that, the Department of Labor might eliminate liquidated damages. So you have to have a good faith reliance on advice from the Department of Labor or a lawyer. There's some cases that say if you relied on a CPA, courts have considered that in reducing or eliminating liquidated damages, but the Department of Labor itself will not accept that. Has to be a lawyer or somebody from the U.S. Department of Labor that gave you that advice, and you have to have it documented. You can't just say, oh, I called the Department of Labor and they said this person would be exempt. That's not good enough. You have to have a written letter of some kind documenting to avoid liquidated damages. Under federal law, not only might you be liable for the back wages and liquidated damages, but there's something called civil monetary penalties. So for every infraction, for every employee that you didn't pay overtime to, and for every employee that you didn't track their hours, which is a separate violation, and for every employee that you violated any of the provisions of the Fair Labor Standards Act, you could be liable for up to I think it's about $1,100 per violation now. And they have some kind of secret formula that they use to adjust that given the size of the employer. So if you're a relatively small employer, they might bring it down a few $100s per infraction. So that's that. Now, generally under the Fair Labor Standards Act, the Department of Labor can go back 2 years, but what they call for a willful violation, they could go back 3 years. And willful means a lot less than it sounds. Willful means I didn't know what the law was. That's willful. Ignorance of the law is a willful violation. So if you don't have to say, well, I knew what I should have done and I just decided not to do it. That's what you would think willful means. No, the Department of Labor interprets willful as meaning you didn't make an effort to make sure that it was you were in compliance. So that's what so they usually will go back 3 years. And again, if you have a letter from a CPA or a letter from an attorney, you might avoid that 3 year and keep it down to 2 years. Then another problem in all this for associations is the person responsible for making sure that the people are paid have individual liability, personal liability. That gets complicated under an association's operations. So who is the responsible person? Is it the board? Is it the board president? Is it just the officers? And I will tell you that your employment practices liability insurance does not apply to this. Your D&O coverage will probably not apply to this. The wage and hour laws are excluded under all these policies. So it can get dicey. Now, usually the entity that's is responsible for paying overtime has the capacity to pay it. It's only when the association or entity is bankrupt and can't pay it do they go after the individual. So they're not going to pursue board members unless the condominium association collapses and everybody folds and there's no money left. And So it's unlikely that they'll pursue individual liability in an association context. But you're in addition, if you're sued, there's attorney's fees available. And technically, there are criminal penalties available under the law. I haven't seen it being used. And injunctions, the Department of Labor can go get an injunction and say you have to comply with the law. And like I said, it's usually not insurable. These are the records you have to keep, by the way. You have to keep records for at least 6 years. The records have to show the name of the employee, their home address, their social security number, the occupation, their rate of pay, hours worked. Okay, so you don't have to do this if they're exempt. But if they're not exempt, you have to have all this information. And this, again, this would be a separate violation, another $1,000 penalty if you didn't do this for your resident manager. Rate of pay, hours worked each day and each work week, total straight time and overtime wages, the amount and purpose of additions to or deductions from wages, total wages paid each pay period, date of payment, pay period covered, date of hire, and date of termination. You need that for every non-exempt employee under state and federal law. That's it.
Wow.
That's what I had to share with you. So I know we have a little bit more time. So, Raylene, do you have some questions you want to throw at me?
This comes up every year. So bonus, well, it's referring back to bonuses. Some condos will give their employees a year-end bonus, but I heard, I think last year was the property manager told them not to do that anymore because it's part of their income. They're trying to make it like tax-free kind of a thing. And then in this one association, all the owners caught wind of it, but they loved all their people that they actually created on their own, created a pot for everybody to donate whatever you want. And then they split up among the employees, but they were told they couldn't do that anymore either. So
it's complicated on these year-end bonuses as to whether it's taxable income and the employer has to withhold from it. If the employer collects the money and then distributes it, it's one thing. But if homeowners on their own decide to give money to the employees, that may be permissible, but it's a more complex issue under tax law than you would think.
Oh, okay. It's the tax man cometh.
Yeah.
Okay. And I also just wanted to remind everybody that, besides Condo Insider, they can always go to YouTube or the Department of Labor. They have videos, a lot of videos actually, that especially on this one, on this particular thing, but they have videos on other topics too under the Department of Labor website that you can always go back and refer to when you have questions or need to educate yourself on certain things.
And Raylene, I would say that anybody that really wants to understand this, particularly the federal law, can go to the U.S. Department of Labor website, U.S., not state, U.S. Department of Labor website. And there will be links to educational videos on this law that I just tried to explain to everybody. In addition, there's like a question and answer tree that they can walk you through. They'll say, do you have this much income or expenditures during the year to determine whether you as an employer are covered? If yes, go to page 2, and then it'll walk you through each of the exemptions. Does the employee get paid X amount? If so, then does the employee perform these services? And it'll walk you through each of the exemptions for anybody that you want. And it's very user friendly. Once you get onto it and see how it works, you can benefit from taking advantage of your tax dollars at work.
Yeah, they were pretty good videos. I was clicking on some and I went, oh, this is easy, and it was kind of easy to listen to. They weren't so like statistical, I want to say, so it was kind of good. And it's available 24/7. So anybody can view it. Can't sleep at night, turn that on. Might make you to go sleep though. So again, John, I really want to thank you for your
Sure.
participation with White Council, with our Condo Insider, with our Board of Director training that we do every year. We really, really appreciate all the education. And again, everybody, when you're doing your budget, it's when you look at those salaries and wages for your employees, it's not necessarily an automatic raise, but it's just sometimes it's going to be compliance with the new laws, So you have to be aware of that, especially your owners. If they look at the budget, well, they got a raise. Well, not necessarily. It's because we have to comply, right?
Yeah. And there are morale issues that go along with that, right? So that
Yeah.
if you're moving your resident manager up from 36,000 to 48 this year, the assistant manager is going to say, well, how come I don't get a raise? And then it's going to be the maintenance manager, and then it's going to be the guy down below that said, well, look, the boss just got a $12,000 raise. What about me? And so there's morale issues that boards have to think through when they decide whether to boost somebody's salary to make them exempt without addressing the pay gap between that person and everybody else in the organization and how that might play out.
Yeah,
And for
they
that,
may have to
and
restructure.
yeah, and for good reason, a lot of associations say, well, we just don't want to pay that much. So we'll treat them as a non-exempt employee. We'll figure out what their hourly rate is and make them keep track of their time. We want to know what they're doing anyway, so we're going to make them keep track of their time. So I'm finding a lot more associations, once they face this, are going from treating people as salaried exempt to, no, we'll just treat them as non-exempt and have them turn in their hours on a weekly basis. One thing about weekly basis, you get to decide what that 7-day period is. Both state and federal law says the employer can set what the work week is. So you decide whether it's Monday through Sunday, Tuesday through Monday, Wednesday through Tuesday, any consecutive 7-day period you can set. And, depending upon workflow and work needs and the association's operations, some do, through Sunday, some do through Saturday. And, given the nature of operations, sometimes weekends are an unusual period. And you split the weekend so that extra day of what is usually a day off doesn't factor into creating overtime. So,
Yeah.
and it becomes a puzzle of scheduling and tracking hours and all the rest. But there's ways of managing it and working with a good payroll service and understanding what the laws require. Now, I probably should mention one last thing. A lot of businesses think, oh, well, I'll just give them comp time. They can keep track of their overtime and they can take a time off later. There is no such thing as comp time for non-exempt employees. So if I'm truly a salaried exempt employee and I'm working extra hours and the board says, boy, you really put in, an extra 20 hours this month for that project that we had to do with the elevators. So we're going to give you, 20 hours of extra vacation. That's fine. You can do that anytime you for exempt employees, salaried exempt, truly exempt. Comp time you can give them comp time, but non-exempt employees who don't meet the exemption test, either because of the salary level or because of the duties, cannot take comp time. So if I'm entitled to overtime, I must be paid time and a half. There's one exemption. But state law says this specifically. Federal law does this off the books by practice. If you work overtime in one work week, rather than get paid time and a half for that work week, you can take time and a half off in a subsequent week if it's within the same pay period. So they allow you to offset overtime in one week with time and a half off in a following work week if it's within the same pay period only. So like if we have a 2-week get paid every 2 weeks, and in week one I work an hour of overtime, so I work 41 hours in week one, then I only have to work 38 and a half hours the following week, and I still get my full 80 hours. I don't have to get overtime for the first work week.
Well, that's cool. That's cool to know.
Yeah, but that requires careful tracking of weekly overtime and making sure somebody takes off the following week. And what unfortunately happens is the employee tracks that and says, "Well, I couldn't take off time and a half the following week. My boss said I had to come in," and then then you have overtime liability building.
Yeah.
So comp time is discouraged unless you have somebody writing on top of it to make sure they do it correctly. And there are good managers, resident managers and site managers that carefully monitor using overtime and offsetting it within the same period to avoid overtime liability.
Right. So
Okay.
as you, it's budget, we're entering into budget season. And so not only just your employees, but if you have contracted, there's some people that really don't have a resident manager, but they have offsite personnel that comes in. So if you see a bump in their contract, that's really because they have to meet their own wage and hour requirements. So
Raylene, that brings up a good point too. Remember when we talked about supervising 2 or more full-time employees? That does not include contracted employees. They have to be the association's direct employees. So I may be a resident manager and I supervise 10 security guards from Securitas, and I supervise half a dozen maintenance people from some maintenance company. That doesn't count. They have to be your employees that they supervise, and they have to have the authority to hire and fire those employees in order to be exempt or recommend. So
that could be
just to make that clear. Yeah, everybody's trying to avoid becoming an employer for good reason. So, but some other day we could.
It's easier.
Some other day we could talk about independent contractors, because that's the other rule that changed. The U.S. Department of Labor changed the law with regard to who's an independent contractor and said, we're going back to what the economic realities test was all about. We're going to look at 20 different factors as to whether they truly are engaged in a separate business or whether they're really dependent upon you, the association, for their livelihood.
Yeah.
So be careful.
Be
careful whether you treat your resident manager as an independent contractor too, because that's another whole ball of liability that could really work to the disadvantage of your finances as an association.
Yeah, there's plus and minuses with using outside vendors for like your landscaping, gardening, kind of stuff, maintenance, doing the floors, because sometimes they're easier to let them go for non-performance than it is an employee for non-performance. Sometimes it gets really hard.
Yeah. And it depends on what laws you're looking at too, because oftentimes, even with your quote unquote contracted workforce, boards and resident managers tend to exercise enough control over what they're doing that the association remains a joint employer with the independent contractor company. So you have to kind of take a hands off and say, okay, we want the property maintained nice and clean, and not specify what they should do every day. So, if the resident manager is telling the maintenance crew every day, come in, have a meeting, we can tell you what to do today. Okay, these are your hours. That they're not independent contractors. They're joint employees.
If their contract is written and says, okay, you got to do sweep the hallways every week. Like certain plants need to be trimmed to avoid this, and this issue, but it's written within their contract. Then that's kind of different.
If you specify the end result and leave to the contractor the method and means and manner in which it's done, then they're an independent contractor. But if you start saying, this is how you do it, this is when you do it, then you're exercising control over them that eliminates them being independent.
I like to use the mopping of the floor. Some people are like, they're not mopping the floor right. And I go, yeah. Some go this way, some go that way, and I go, at the end of the day, is it clean?
Yeah. And the thing for the board to do is and owners, if they feel like your contracted services are not performing, you talk to the board, and then the board, whoever's in charge of the resident manager, contacts the company that you've hired and say, we don't think you're doing a good job. You go tell your employees to sweep this way or mop that way. But we're not going to tell them. It's your job to make sure it's done the right way. So we're not happy with your work, and we're going to replace you with a different contractor unless you start doing it the right way.
Yeah, exactly.
So you got to go through the country. You don't want to intervene with their employees and tell them how to do their job.
Yeah, because then that leads to another conversation. Hostile work environment. That's another can of worms.
Somebody
Want to get involved. Yeah, that gets more complicated. Okay, thank you.
I think I just got somebody to join us. There's Chris.
Yeah, he's on at 11.
All right, Chris.
John Knorek, good afternoon. Morning still, sorry.
Good to see you, Chris.
Okay.
All right.
Have a nice rest of your day, John. I appreciate it.
Thank you.
Thank you.